Hi, it's Antonia Mercorella, CEO of the REIQ. Thanks for joining us for this very important update. Yesterday, on the 23rd of May 2024, the Queensland Government passed the Residential Tenancies and Rooming Accommodation and Other Legislation Amendment Bill. It's a bit of a mouthful. I'll hereafter refer to it simply as the bill. Now, what this bill, of course, encompassed was Stage 2 rental law reforms, and of course, pleasingly, it's also the bill that creates the pathway for the introduction of continuing professional development for all real estate professionals here in Queensland. But for today's purposes, I want to focus quite specifically on those Stage 2 rental law reforms and what they mean for real estate practitioners, predominantly for property managers, but actually also even for salespeople. And I'll explain why they're relevant to salespeople in just a little while. Now, just to be very clear, today I will be providing a potted summary of what those Stage 2 rental law reforms look like. But certainly this video will not be enough. And so to that end, rest assured, as your peak body, we are coming to every corner of the state to deliver very comprehensive training to ensure that every property practitioner in Queensland is ready for these new laws and will be compliant. So we have, starting off on the 5th of June, we will be coming to 12 different locations over the course of 3 weeks. And you can find the dates of those roadshow in the video below. Now, what we'll be doing at that roadshow is, of course, as you would expect, we will be taking you through what those Stage 2 rental law reforms look like. But importantly, we will be delivering really practical information. So we'll take you through frequently asked questions. We'll take you through a series of practical scenarios just to make sure that you understand how these new laws will work in real world, day to day in your business. We'll also be taking you through a suite of new resources that we have developed to help you navigate these new laws. So that's going to be a series of new RealWorks forms, lots of new checklists, and we'll have a whole new toolkit that we will be providing to people at the roadshow. So rest assured, there's plenty of training and information coming your way very shortly to make sure that you are ready and able to successfully navigate this new legislative landscape. So what I wanted to start with today in this video is the changes that are coming and that will start very, very shortly. So the changes I'm about to talk about commence on Ascent. Now, we don't know what that date looks like as yet, but we expect that it's likely to be within the next week. So what I'm about to take you through will commence virtually immediately. So let's start with rent bidding. Now, you've heard the government talking a lot about the fact that Stage 2 rental law reforms will make rent bidding unlawful. Now, of course, we all know that rent bidding is already unlawful in Queensland. But the key difference is this. Today, under current laws, a lessor or a property manager cannot ask or solicit for more rent than the advertised asking price. But, of course, a tenant may offer more rent, and it's not unlawful to accept that greater offer. When these new laws commence, it will be unlawful to accept a greater amount of rent. So that's the key difference. Now, of course, that will mean that you will need to have certain conversations with your lessors, and we'll cover that at the roadshow about how to successfully manage those conversations. Now, let's move on to rent in advance, some very significant changes in this area. Now, again, today, a tenant may offer rent in advance, 6 months rent in advance, for example, or 3 months rent in advance, and you may lawfully accept that. Now, previously, I do want to acknowledge a really significant victory we've had on this particular issue. So previously, when the bill first went into Parliament, what we were really concerned about is that what was being proposed is that a tenant would be prevented from paying more than 4 weeks' worth of rent in advance ever, at the beginning and throughout or during the tenancy. And of course, as you can imagine, that would have created some real difficulties for tenants who choose to pay rent in advance and have good reasons for doing so. So the tenant would have been disadvantaged. But in addition to that, as a property manager, you would have been committing an offence if, through no fault of your own, the tenant had inadvertently paid more than that statutory limit. And you would have been up for potentially a penalty of $7,000. So there has been an 11th hour amendment to this that was made yesterday before the bill was passed, and it's a significant one. And here's how it works. Basically, what will happen is during the tenancy application process, the only rent in advance that can be accepted is for 1 month for a general tenancy and 2 weeks upfront for a periodic tenancy. So that's at the beginning of the tenancy. And the intent is to create a level playing field at the tenancy application stage. So in other words, someone can't come along and offer more rent and can't come along and offer to pay, for example, 6 or 12 months worth of rent in advance. So that's what the intent is. However, during the tenancy, if a tenant wishes to pay rent in advance, for example, 3 months or even 6 months, it will be permissible for you to accept that rent in advance, and you will not be committing an offence if that's the case, if that's what the tenant wishes to do. So I think that's a significant win. It would have been a truly difficult and administrative nightmare otherwise for property managers who would have literally needed to monitor the account on virtually a daily basis to ensure you weren't committing an offence. So we're incredibly proud of that significant win. So let's move now on to rent frequency limits. Now, this is probably the most controversial change of all. Now, you'll all remember that last year the government amended the laws to say that rent can only be increased once every 12 months. Now, the law is now well established on that point. This, however, goes a step further. We believe it goes too far. And what it does is that law or that limit on that rent increase frequency, instead of attaching to the tenancy agreement, it actually attaches to the property itself. And this is why salespeople need to actually pay attention to this particular issue. This will have a significant impact on the contract process. And of course, it will also mean that we will need to amend the REIQ contract to allow for this. Why do I say that? Well, because this law attaches to the property, it will mean that even if there is a change in the tenant, so the tenancy ends and a brand new tenant comes along, you will still be limited and you cannot increase that rent for at least 12 months since it was last increased. And similarly, if the property is sold and a brand new lessor comes along and chooses to put that property back onto the rental market, that new owner will also be bound by that limitation and cannot charge more rent than what the previous owner was charging. So you can imagine that brings with it a series of very practical issues and contractual issues. And of course, to add to that, the tenant gets a right under these new laws to actually ask for a copy of the previous tenancy agreement to satisfy themselves that they are not being charged more rent than what was previously being charged. So this represents a very significant shift in tenancy law. And of course, we will take you through all of the practical implications and help you navigate all of that when we come for the roadshow. And of course, we'll also provide you with information about how on earth you're going to provide someone with a copy of a tenancy agreement without committing, of course, a privacy law breach. So certainly there's going to be some changes that will need to happen to ensure compliance with that particular new provision. And just finally, before we leave that issue of rent increases, there is a provision for undue hardship that the lessor can rely on. If a lessor believes that they will be caused undue hardship because they cannot charge more rent, they do have a right under these new laws to go to QCAT. They will have to establish undue hardship grounds. QCAT will consider it, and of course QCAT will also consider the impact that it would have on tenants. Now let's move on to some other miscellaneous changes that will start upon assent. There will be a new entry ground. Now this is to allow for the installation, maintenance or replacement of smoke alarms. We believe that this is an important victory. We want to ensure that you are able to gain access to the property to make sure that those smoke alarms are properly maintained and installed. We all know that that's absolutely imperative to ensure the safety of the tenant and their occupants in the property. There will also be some changes to the confidentiality provisions that relate to domestic and family violence provisions in the residential tenancies legislation. And then what also will start upon assent is a series of new head of power provisions, and they relate to portable bond schemes, code of conduct, the introduction of a code of conduct, and of course also modifications on the basis of accessibility, safety and security. Now, just to be very clear, the way that this will work is that the head of power will commence, and that will create the foundation for a regulation to be made at a later date in respect of those three matters. Now, just finally, I'd like to take you through, they're all of the changes that will commence immediately upon assent. As I said at the outset of the video, there is a second tranche of changes that will commence upon proclamation. So that's at a later date. So I'll just quickly take you through what they look like to give you a bit of a flavour of what's coming. There will be a new standard or prescribed tenancy application form that will become the mandated form that is used when an application is made for a tenancy, and linked to that will be prescribed information that you can ask for when a tenant is making an application for a property. And as you would expect, we will continue to advocate for what that form looks like and what that prescribed information looks like as your peak body. There'll also be some new verification requirements, verification of identity requirements. There'll be a requirement to provide at least one fee-free, that's hard to say, at least one fee-free rent payment method that must be offered to the tenant. A lessor will be required to substantiate any bond claims within 14 days. So there'll be an introduction of a statutory time limit in respect of that. And quite a significant reform is one that relates to bonds and the amount of bonds. Now, of course, today, under current laws, it's 4 weeks' worth of rent, but if the weekly rent is $700 or above, then the parties can negotiate between themselves as to what that rent amount will be. When these new laws commence, it will be limited to 4 weeks, irrespective of the rental amount. Now, what we are concerned about is that, again, there's a degree of retrospectivity involved in this. So, of course, today, if you've got bond that is above 4 weeks, you would have lawfully, presumably, negotiated that on the basis that the weekly rent was more than $700. When these new laws start, the tenant will have the right to claw back any amount that is above that 4 weeks. Now, we think that's impractical, and we think that really the new laws simply should have said they don't apply to any existing bonds. They only apply to new bonds from when the new laws started. We think that's going to create quite an administrative burden for both the Residential Tenancies Authority and, of course, for property managers as well. And another significant change, but again, one where we've had a victory, is there will be some changes to when it comes to bills for service charges and water consumption charges. There will be a statutory time limit of 4 weeks. So basically, you will need to get those bills to a tenant within 4 weeks from receipt. Again, previously the bill had proposed some changes at the end of the tenancy, which would have seen potentially lessors liable for water usage for tenants. And so we have had a win on that, where we've said that at the end of a tenancy, you as a property manager or a lessor can actually issue a final bill based on the estimated water usage using the right fee or service charge, and of course there are some requirements to substantiate that, but basically it will mean that the tenant can be charged for their water usage even if the tenancy ends before the final official bill is issued. And of course that's really relevant in areas like Toowoomba or Bundaberg, where water bills only get issued every 6 months. So that's a really, I think, a significant victory. Couple of other miscellaneous changes. The entry notice period goes from 24 hours and it's doubled and becomes 48 hours. There'll also be some limitations on the number of times that you can gain access to a property where either a Form 12 or a Form 13 has been issued. There's going to be a new process where a tenant makes a request for a fixture to be added to a property or for a structural change to the property. Again, an 11th hour amendment last night was made to that provision to make that subject to body corporate approval where the property involved is in a community title scheme. So that's a really important amendment. There's also going to be, this is quite significant and quite new for Queensland, the introduction of a formula for calculating reletting costs in a break lease scenario. And finally, there will be some new requirements that apply to the way that you go about collecting and storing personal information of tenants during that tenancy application process. So, ladies and gentlemen, as you can see, these laws are quite extensive and quite material and significant. It is really important that property managers familiarise themselves with these new laws. And again, I really want to emphasise that today I've not gone into a great level of detail. I'm really just trying to create some colour for you around what's coming. It is really important that you don't just rely on this video. We do need you to come along to those training sessions that we're holding all around the state. It's really important to us that we keep you safe and compliant. So please make sure that you do come along. Many of these new laws carry with them significant infringement penalties of up to $7,000. So again, really important that you do educate yourself on these changes. And of course, as you can imagine, we are working really hard behind the scenes. We have put out some articles today. We're working on updating our new tenancy laws toolkit. So that will be coming your way in coming days, and that will have a series of practical guidance and information for you. But really, the key thing is coming along to that roadshow where we will really take you through very comprehensively these new laws and get you ready. And look, finally, let's end on a really positive note, or what we believe is a positive note, introduction of continuing professional development. Now, this is something the REIQ has been advocating for a decade now, so the wheels turn very slowly, but we have been tenacious and we finally got there. We won't see CPD commence for another 12 months because the Office of Fair Trading obviously will need to get ready. But this brings Queensland into line with most other Australian jurisdictions. And of course, what it will mean is that every real estate professional will be required to ensure that they are doing annual training to keep their knowledge up to date and to remain compliant. We think this is an incredibly important step forward for the Queensland real estate profession. And of course, we think it will really enhance consumer protection in Queensland and the trust in the Queensland real estate community. So I know that many of you are very supportive of this, and I want to thank all of you who have helped us and supported us along the very long journey to get here. So, ladies and gentlemen, I know that's been quite a long video and quite and probably quite boring to sit through, but it is really important information. So please pass this video around, share it with your real estate colleagues. We want to make sure that we are keeping every single real estate practitioner in Queensland informed about these new laws. We really look forward to seeing you on June the 5th and thereafter at that roadshow. And of course, in the meantime, REIQ members can call our property management support service if you have any questions or concerns on anything property management related. Thanks for watching. Happy weekend. Stay safe. See you next time.